All right, well, it's 1 o'clock, so we'll go ahead and get started. Appreciate everyone taking the time to join us today. Welcome to the Moss Labor webinar series. My name is Tom Bortnick. I'm the Senior Vice President and General Counsel for Moss Labor, and I also head up the Moss Enterprise business unit, which handles all of sort of the non-traditional visa classes. So that would include things like TN, as well as our immigration visa programs like EB-3. And EB-3 is what we're going to be talking about today. So for those of you who don't know, EB-3 is the employment-based immigration classification for other workers. And so this presentation is specifically aimed at people who are currently using the H-2A and H-2B programs to look at long-term solutions to those labor needs, and specifically trying to convert H-2 workers into green card status and what that process looks like. So we'll go ahead and get started. I guess it may be helpful just right off the bat to kind of talk big picture. So in the immigration world, there's really sort of three avenues that you can come to the United States to be a lawful permanent resident. So you have your humanitarian classes, refugee status, asylum, things like that. You have family-based immigration, right? And you also have employment-based immigration. And so those are the three kind of big buckets of immigration that exist. Now, both family and employment-based immigration require sponsorship. And sponsorship is basically you have someone in the United States who's an interested party who's vouching for that foreign individual, right? So they're acting as a guarantor of sorts. In the family context, what you're talking about with sponsorship is immediate relatives. You're talking about people who are spouses, who are children, perhaps. And those immediate relatives can certainly sponsor foreign individuals for green card status if they are themselves a U.S. citizen or a lawful permanent resident. So if they have green card status, they can sponsor an immediate relative. Now, U.S. lawful permanent residents, green card holders, are limited to sponsoring spouses and children, but that is an option for family-based immigration. For employment-based immigration, what you're talking about is a U.S. employer. So in order to pursue employment-based immigration, you have to be sponsored and have a job offer for full-time year-round employment from a U.S. employer. And again, this is what we're going to be talking about today. It's important to understand that when you're talking about the immigration system, you're talking about a system of quotas. And there are quotas based on country of origin, and there's quotas based on the type of individual being sponsored. What are their qualifications? What are their experience? What's their educational background? And what job are we placing them in, right? So rightly or wrongly, and there's all sorts of political debates about what priority should be given and to whom, but taking the politics out of it, right now the government prioritizes workers with extraordinary ability, with advanced degrees, or some type of specialized knowledge, right? Those kind of get to the front of the line. Lower priority is placed on foreigners without such qualifications. And with that, you're really talking about people without college degrees, maybe a limited work history, or at least in jobs that don't require significant educational or work experience. And so to manage these different priorities, right, to figure out who's at the front of the line, who's kind of waiting their turn in line, there's a series of preference categories. And I'm going to talk about, kind of the big three. There's 5 different preference categories, but we'll kind of go through each of these. EB-1 is your classic extraordinary ability, right? It's your Albert Einstein, it's your Olympic gold medal winners, whatever the case may be, but foreigners with extraordinary ability in some field, science, art, education, business, athletics, with some type of national or international acclaim. Those individuals, they actually don't need employer sponsorship at all. They can self-sponsor. You also have EB-2, which is reserved for foreign professionals in jobs that require an advanced degree. So doctors, highly skilled researchers, people with exceptional ability. One step below extraordinary ability, you have your exceptional ability crowd. And then finally, you have EB-3, which is sort of a catch-all category for everybody else. So what you're talking about are skilled workers, people who have 2 years or about 2 years of professional experience or some type of associate's degree, perhaps. You have professionals who maybe they do have a bachelor's degree. And then you have this other workers category. And this is where the vast majority of H-2 workers fall into, right? They don't necessarily have college degrees. They don't necessarily have multiple years of work experience. And so they fall into that other workers category. So diving in on the EB-3 side, right? And there's subcategories to all of this, but we're looking at EB-3 specifically for purposes of this presentation, and in particular, the other workers category. EB-3, you can kind of think of the sponsorship process as being into two different categories. You have the employer side of the process, what they need to do to sponsor the worker. And then you have the worker side of the process, which is what the worker actually has to do to actually get that green card status. And so if we think about the employer side of the process, which is that's what we specialize in, that's our bread and butter, there's really kind of three main stages. The first stage will be very familiar to anyone who's used the H-2B program before. You're starting out with a prevailing wage determination. And so that's establishing the minimum wage that must be advertised and paid. There's also a recruitment period, and that should be familiar to anyone who's used the H-2 programs before, because a lot of the steps are exactly the same. One of the key differences is that your recruitment is occurring before you even begin the filing process with the Department of Labor. So you're talking about sort of a pre-filing requirement, as opposed to the H-2 world where you submit your application and then you do recruitment. So you have to complete that recruitment before you even start the process. Next, you have the Department of Labor side of things, which is obtaining a permanent labor certification. And this is very much the flip side of an H-2A or H-2B temporary labor certification, right? A permanent labor certification is a determination by the Department of Labor that you have been unsuccessful in filling a year-round job opportunity. So the job opportunity is year-round, it's full-time, and you've come up short as far as domestic applicants are concerned. And you need to fill that with a foreign worker. Now, another key difference here is that with a permanent labor certification, it's not just a blanket number of workers, right? In the H-2 world, you can request 1,000 workers on a single labor cert. That is not the case with the PERM program. With a permanent labor certification, each individual worker that you're sponsoring is going to have their own individual labor certification. And the same is true for the immigrant petition. So once you get through the labor certification process, you can then file your immigrant petition with U.S. Citizenship and Immigration Services to kind of kick off the worker side of things, what they have to do to get the green card. And again, that's individualized to that specific worker. So kind of diving in on each of these main stages. Again, first stage is the prevailing wage determination. That's the minimum wage that has to be paid. And of course, positive recruitment, where once you can start conducting that recruitment, you're obligated to offer employment to any qualified U.S. worker who's able, willing, and available for the job. Again, for anyone who's familiar with H-2, it's going to look very, very similar to that. And so the prevailing wage is going to be specific to the occupation and the cities and counties where work is performed. So it's going to be individualized. The government gets data from the Bureau of Labor Statistics on particular occupations and will assign a wage rate that is the highest of all the duties being performed. Very familiar to most H-2B employers. And for H-2A employers, it's very similar to how the government is enforcing the new adverse effect wage rate as far as OEWS categories are concerned. Now, what I will note is that in the PERM program, a PERM prevailing wage is typically lower than the same occupation in the H-2B context. Now, there's a lot of reasons for that. The principal reason is that H-2B is aggregating all skill levels for that occupation. So they're taking an average of both entry level and the people that have been doing that job for 10, 20 years. In the PERM program, it operates a little differently. And they actually do take skill level into account, and they tailor that specific prevailing wage to whatever the skill level is for the actual position. So it is a little bit lower. What I will say is that you do need to be cognizant of corresponding employment rules. So it is often the case that if you're sponsoring H-2 workers, you may nonetheless voluntarily pay the higher H-2 wage simply because you're going to have to pay that anyway while they're corresponding workers. So there may be good reasons for that. If the occupation is totally distinct, you wouldn't have to do that. You would just have to offer the PERM prevailing wage. Now, the recruitment obligations, again, very similar to H-2. There's a job order with the state workforce agency. For anyone who's been in the H-2 programs long enough, you probably remember newspaper ads. Same deal here. You do have to run 2 newspaper ads. If it's a local paper, you can run 2 Sunday ads. If your local newspaper does not have Sunday Sunday newspaper, you can run a non-Sunday ad in the largest newspaper in the area. So typically that's going to be more expensive, but that is an option. And then there's an internal posting requirement as well. And certainly if you are subject to a collective bargaining agreement, you would contact your collective bargaining rep in lieu of posting that internal notice. There's other requirements as well. If you're pursuing workers outside of the other workers category, there's additional recruitment steps you would have to undertake for EB-2, for example. But for our purposes, we'll just focus on those core requirements. Now, what I will note is that there is sort of economy of scale here when it comes to sponsoring multiple workers at once. So the reason for that is because if you're sponsoring multiple workers concurrently at the same time, they all start the process at the same time, they can all rely on the same prevailing wage in the same recruitment period. You just advertise the number of positions you have available. And so what that does is it means that the more workers you sponsor at a given time, the lower your overall costs per worker will be, because they're all sharing that initial stage of the process. And that's what's known as batch recruitment. So there is a cost savings factor there as well to consider. Now, when we get to the labor certification stage, that involves an application to the U.S. Department of Labor. As I mentioned, each worker will have their own perm application. Now, one other kind of commonality with H-2 is that there's going to be audits. Audits are very common in the H-2 programs. In the perm context, the audits actually take place during the filing process. So before you even get that approval, you could be subject to an audit. And in fact, most perm applications, especially those filed on behalf of H-2 employers, will be subject to audit. Now, those audits are fairly routine. They're not overly burdensome. They typically don't ask for things like payroll that you would see in a wage and hour audit, but it can add time to the process. And so that's just something to be aware of. Now, in terms of timing, you have a 6-month window to file your perm applications after you initiate recruitment. So remember, recruitment takes place before all this. Once you start that recruitment, the clock starts ticking and you have a 6-month window to complete the perm applications. The earliest you're able to file is 30 days after recruitment ends. So after you post that job order for 30 days and you do your newspaper ads and you do your internal notice, there's a 30-day cooling off period where you still have to accept U.S. applicants, but you're unable to file your perm application. So it's best to think of recruitment in terms of a 60-day process because you have your actual recruitment and then your 30-day cooling off period before you can start the perm process. Now, the application, it is individualized to both the employer and the job opportunity, but more importantly, it's personalized to the worker. So it's going to have the worker's personal biographical information as well as their work history. That's all going to be included on the face of the application. And of course, the work history listed on the perm application has to demonstrate that that worker is qualified for the job. And so this is a unique requirement to the perm program. So if you have an experience requirement, the worker is going to have to show in their work history that they meet that experience requirement. Now, and a really important caveat on that is that that has to be experience gained outside of your business, right? So if you have a 3-month experience requirement and that worker has only ever worked for you, let's say an H-2B status, they're not going to be able to use the experience they gained at your business towards that experience requirement. And so that's just one thing to keep in mind. For this exact reason, a lot of employers choose not to include an experience requirement because they just know that they won't be able to document that the workers possess that experience. In other cases, maybe the workers have a longer work history and they are able to do it, then it may be appropriate to include an experience requirement. Again, just something to be aware of. Now, after we receive certification, the employer is then able to file an immigrant petition with U.S. Citizenship and Immigration Services, again, individualized for that worker. And this is the final stage of the employer side of the process. And this is where there's a bit of a passing of the baton to the worker attorney who's handling the worker side of things. And so this is sort of where our role in the process would wrap up and where we'd start to coordinate with the worker side of things. So employers can file that petition at any time during the validity of the perm certification. So from the moment it's issued, you have a 6-month window to file those immigrant petitions. And we'll talk about why the timing of that. It may not be like H2 where you file the petition right away. There may be strategic reasons not to, but you have a 6-month window. It's valid for 6 months. And the petition may also list dependent spouses or children. So this is the first time in the process where they would actually indicate whether they intend to pursue family-based immigration concurrently with their own employment-based immigration. So there's actually a spot on the petition where they would indicate the names and other, personal information of spouses or dependent children who they intend to sponsor for family-based immigration. Now, the other kind of key concept here that we'll talk about in greater detail is how the worker actually obtains the green card. And they'll need to make a choice at the time they file that petition to either pursue consular processing or an adjustment of status. There's very key factors that go into that determination. But it basically refers to the method by which they get their green card once the petition has been approved. Now, if it is filed as an adjustment of status, the petition process will look a little bit differently because it's going to be happening concurrently with paperwork filed by the attorney who's working with that worker. And so there'll be a separate petition for the adjustment of status itself and an application for what's known as an EAD, or Employment Authorization Document, which is a temporary interim work authorization while the green card is pending. There's also what's known as an advance parole, which is basically a travel authorization. So it allows them to leave the country while their green card is in process. And those are sort of 3 separate applications that have to be paired with the immigrant petition if they're going to pursue an adjustment of status. If it's consular processing, at this point in time, it's just the immigrant petition. And so diving into this dichotomy between consular processing and adjustment of status, basically the way to think about it is in country versus out of country. If workers are obtaining their green card through consular processing, it means that they are waiting outside the United States and they are basically scheduling an appointment at a U.S. consulate or embassy in their home country to obtain their green card. So it's via the State Department. And so what happens is that once that petition is approved by Homeland Security, by USCIS, they'll kick it over to the Department of State, and it goes to what's known as the National Visa Center. And the National Visa Center is going to coordinate all the process from there, and they'll notify workers when visas become available, and they'll work with the attorney and us to coordinate an interview for that worker to actually receive their green card. And so once that immigrant visa is issued, the worker can legally enter the United States as a lawful permanent resident, and the green card will come in the mail typically 90 days later. And that's what that process looks like. An adjustment of status, on the other hand, is in country. And so what this means is that the workers actually obtain their green card while they're here. So if they come into the U.S. in H2 status, they can work until the end of their H2 validity period. And then as long as we filed that adjustment of status petition, they can hang out until that green card is actually issued. And as I mentioned, there's what's known as the EAD and the advanced parole. That gives them temporary work authorization while that green card is pending. So that's a great deal if you can make it work because it allows the workers to stay here. Now, what I will note, though, is that there's a lot of stars that have to align in order to make that happen. So first and foremost, at the time the petition is filed, the workers have to actually be here, right? And for H-2B employers that rely on the lottery, that's not always a sure thing. The other thing that I would add to that is that they have to be here for at least 60 days by the time we file that petition. So it's not a situation where they can show up on April 1st and immediately file an adjustment of status petition. There's a 60-day window that they ideally would run all 60 days, because any time prior to that, it could be construed as fraudulent. The government takes very seriously, if they're issued a non-immigrant visa, that the workers are honest and transparent about their intent. And the H-2 programs are not dual intent programs, which means if they're coming here on an H-2 visa, the expectation is that they are going to leave once that visa expires. So there has to be at least 60 days before they file that adjustment status, or else there could be allegations that the worker was not totally transparent and honest about their intentions. And then, of course, the most important factor is that there actually has to be visas available, right? And so, again, I mentioned that there's a quota system. There's a finite number of immigrant visas available in a given year. and that's governed by what's known as the visa bulletin. And if the visa bulletin is current, the government will accept an adjustment of status petition. If it's not current, they won't accept it, and the worker has to pursue it through consular processing. So more on that. Basically, the EB-3 category has 40,000 immigrant visas available in a given year. And so that is what the preference category is allotted. It's not a huge number. And it's made even more complicated by the fact that there's only 10,000 visas available for that other workers category, right? So again, that's the one that most H-2 workers will fall into. And so demand, as with any other capped visa program, demand exceeds the available supply. And so what happens is that there is a wait list, and workers have to wait often quite a long time to actually get that visa. It's not a situation where you're capped and that's the end of the story. It just means that you're put on a wait list based on your priority date. And your priority date is the day you start that perm process with the Department of Labor. And so both methods of obtaining the green card depend on that visa availability. And so the key determinant at the time we file that petition is whether visas are available. If they are, great, let's do an adjustment of status. If the visas are not available, meaning they're in retrogression, fancy word to describe a backlog, but that's what it is, then USCIS will not accept an adjustment of status petition, and your only choice at that point is to do consular processing. I guess the key takeaway with that is the uncertainty. And that's a key concept that employers really need to understand if you're going to get into this program and go down this road. There's a lack of control over the timing. We don't control how quickly the government works through the case. There's unpredictability about worker arrival, and that's especially true if you're an H-2B employer. And it's impossible to forecast exactly whether an adjustment of status is going to be possible. It just cannot be done that far in advance. So if you're going to pursue this program, you just need to be aware of these, and you need to be prepared for all possible outcomes. And more importantly, you need to be prepared to pivot, because you may start the process and things look good. By the time you get to that stage, circumstances may have changed. And sometimes you just need to pivot. You need to adapt. You need to accept less than ideal circumstances. And that's something that workers should be prepared for too, because a lot of them don't understand exactly what this process looks like and how long it takes and what the process might be. And so they need to be prepared for that outcome. There may be a time, if they have to do consular processing, where they have to skip a year of H-2 eligibility, right? That's a possibility. They may have to wait on the sidelines in their home country waiting for an appointment availability. And that can be tough for a lot of workers. So just to give kind of an overview of the overall timeline, just to summarize and give you some time estimates. Again, prevailing wage determination, recruitment. Currently, the Department of Labor is taking about 6 months to work through a perm prevailing wage. They may have gotten a little bit faster in recent days just because they've worked through the H-2B backlog, but 4 to 6 months at least for the prevailing wage. You have another 2 months for recruitment. That's 30 days of active recruitment, 30 days of cooling off. So right off the bat, if you had gotten started in this process on January 1st of this year, you'd expect to be in a good position to start your perm applications sometime this summer, right? Labor certification, if you're getting started in the summer, it takes about 7 or 8 months if you are one of the lucky ones that is not subject to an audit. It's a very long timeline compared to the H-2 process where it's only a couple of months. And if you are audited, right, which most employers are, it could be as long as a year or more to get that labor certification. So again, if you had started January 1st of this year, you'd be looking to finish the certification process most likely sometime in the summer of 2025, so summer of next year. Once you do that, you move on to the petition process, and that can take 8 to 10 months on its own. Now, there is a premium processing option. It's mostly applicable only to consular processing cases where you can pay more to get a quicker approval. For adjustment of status cases, it doesn't make a difference because there is no premium processing on the adjustment of status itself. So really, you know, it could be anywhere from 15 days if you're doing consular processing to 10 months or more if you're doing standard processing. And then, of course, the worker side of the process can take up to a year all in and of itself. And that's the time that the petition has been approved and everybody's waiting for visa availability. If visas are current, it certainly makes it easier. If they're not current and there's a backlog, it could take a significant amount of time. What I will say is that most employers, if they're doing an adjustment of status, they can expect that temporary work authorization after 6 months. So that is good news for most employers because they can help minimize the gaps in employment after the H-2 status expires. So grand total, all said and done, 3 to 4 years. That's what you can reasonably budget to get through this process and end up with the workers with a green card in hand. So just think about that when you're getting started, because it's not a short-term solution. It's not a situation where you can sort of, solve the H-2B lottery issues with green card sponsorship. It's a long-term investment. Now, getting into a little bit of the fee structure, I can't speak to how others do it. A lot of attorneys will charge hourly. A lot of attorneys will charge fixed fees. We kind of do a hybrid approach. So we have a series of fixed and variable fees depending on the number of workers. So as I mentioned, there is a economy of scale with doing multiple workers at one time. And for each batch of workers, we charge a flat fee of $4,000. And that covers the prevailing wage and that covers the recruitment. And we also make you responsible for any advertising costs. Generally, it's about $500, but certainly if you're in a larger metro area and you're forced to advertise in the New York Times, it can be a little bit pricey for that. But you'll be responsible for that batch fee plus the newspaper fee. When it comes time for the labor certification, again, each worker is going to have their own. We charge $1,200 per worker for that process. And we charge $1,000 for the visa petition plus government fees, which if you're doing standard processing is $700 per worker per petition. And if you're doing premium processing, you can add $2,800 to that. So roughly $3,500 in government fees plus the $1,000 for our fees. And then, of course, for the worker side of it, the workers are going to have their own legal representation to help with their side of the process. We can recommend attorneys for that. We work with several immigration attorneys, and we've been able to negotiate favorable rates for that based on our volume. And so generally speaking, you can expect to pay $2,000 to $4,000 per worker for that. What I will note here, and this is really important to understand, legally speaking, you are only responsible for the labor certification portion of the fees. You can require workers to pay for the rest of it. So the workers are able to pay for the immigrant petition and their own legal representation. So those are costs that you can pass along to the workers. That's important because that's a big difference than from H-2, where that sort of thing is illegal. So if you are going to make workers pay for it, perfectly fine to do that. We've seen a lot of cases where employers choose to pay those costs on the worker's behalf. That's completely fine. We've also seen a hybrid approach where the employer sort of gives a loan and pays it on the front end, and then the workers will pay it back over time. We've also seen scenarios where the employers offer a retention bonus. So workers will pay out of pocket initially, and the employer, if the worker stays for a certain amount of time after they get their green card, the employer will basically pay them back for any out-of-pocket costs. Those are all viable options. Apologies for the sirens there. So those are all viable options, but the key takeaway is that workers can pay for that portion of the process. So it's not all on the employer. You are only responsible for the DOL portion of it. So in terms of a single worker, if you're just doing one worker, one batch, and going through the process, you can expect to pay around $10,000 or at most $16,000 per worker. And so that's just for one worker to make it through the process, start to finish, all included, government fees, attorney fees, et cetera. Because of the economy of scale with the batch fee, if you do choose to add additional workers, the costs drop pretty dramatically. And so each additional worker after that is much cheaper. It's basically half the cost in some cases for each additional worker. And the more workers you sponsor concurrently, the lower your per worker cost becomes because of that economy of scale. I guess in terms of a takeaway, this is not a casual endeavor, right? Like I said, this is not a short-term solution. It's a big investment. it's a big investment of time, energy, and money. It's a long-term solution for your business. And a lot of employers, it's not worth it to them to do that. In other cases, they have to go this route because it's the only way that they can bring certainty and stability to their workforce. You can't rely on an H-2B lottery every year. This is a good way to pursue that. And so you should view this as a mutual long-term investment. You should view it as a long-term investment for your business, and the worker should view it as a long-term reward for what work they've put in thus far, right? If they've been coming back to work for you year after year, this is a good way to reward those workers for their hard work and for their loyalty. And so both the employer and the worker need to have a conversation about what this looks like, right? Because everybody needs to be on the same page. And so you should understand the issues, understand the challenges, and understand that this is you're playing the long game. You're going to make it work in terms of being a long-term investment. Now, as I mentioned, once the workers get the green card, they're free to go work for anybody. They can go with unrestricted work authorization, work for any U.S. employer. For that reason, we recommend that you don't just sponsor any given worker, right? You should only sponsor workers who have worked for you for some period of time, preferably 3 years or more, because you want to make sure that it's the right person for the right job and that you know them and you know them intimately. Maybe you know their family, and you can rest assured that they are the right fit for the job. Because once you pursue the sponsorship process, you can't substitute workers, right? It's individualized for that worker. And with that comes trust. You want to make sure that the worker you're sponsoring, you want to make sure that you trust them. And you want to make sure that they're committed to the long term as far as working for your business. They can go work for anybody once they get their green card. What makes you think that they're going to work for you? Well, if you're a good employer and you're doing things right and you treat them right, they are going to be committed to you and they're going to be loyal to you. And of course, you can build in incentives to keep them there. But it's really about trusting which workers you're sponsoring. And for those of you that have been in the H-2 programs a long time, I'm sure you know exactly what workers you're thinking about as I talk about this, right? You're talking about your long tenured guys, your top guys, maybe your crew leaders, the people that have been there through thick and thin and that you can rely on. Those are the ones that you want to look to for sponsorship. And tolerance, right? The 3 T's. Tolerance is really about understanding and being patient throughout this process because it is not quick. It is not cheap. It can be difficult. It can be frustrating. You just have to be patient. You have to roll with the punches. You have to be willing to adapt. And you have to persevere. And you have to know that, again, this is a long-term investment and it'll be worth it in the end. But it's not a get-rich-quick scheme. It's not a short-term solution. It's something that you are making a conscious investment in, knowing that it'll pay off in the end when that worker has a green card in hand and they can reliably work for you year-round, right? The last thing I'll mention on the diligence front, there's a lot of unscrupulous people in this industry. Certainly that's the case. I see it all the time. You know, if your email address is in the DOL disclosure database as often as mine is, you'll get solicitations, you'll get spam. There's a lot of people out there offering green card services. Just be careful who you're dealing with. There's a lot of dishonest folks out there, and they don't always tell you the details about how long this process takes. I've seen many cases where people are advertising, you know, get a green card in 12 months. Understand that there's all kinds of sales pitches out there. Not all of them are legit. And so you have to do your diligence about who you're working with. We like to be upfront about all this, the good and the bad about this program, because we want you to make informed choices. What we don't want to do is work with you and get you into a place where, you know, we sold you pie in the sky and you end up disappointed. We want to be completely transparent. We want to be completely honest so that you can make informed choices about your business and you can come into this knowing what the risks and what the challenges are going to be. And that's really, really important to us because it is a long-term process, and you have to understand those risks if you're going to make this program work for you. So just be careful, do your diligence on who you're working with, make sure they know what they're talking about. Also make sure that they know H-2, right? Because there's special considerations when you're moving from H-2 to green card that you need to be aware of. And not every immigration attorney is going to know the nuances of H-2, and that can be that can create problems down the road as you get into this process. So with that, I'll open the floor for questions. I see we have some in the chat already. So will the slides be available after the webinar? Yep, they'll be available. Everyone who attended will receive a copy. No problem on that front. How soon would we need to begin recruitment after obtaining the prevailing wage? So you can begin recruitment at any time while that prevailing wage is valid. And the validity period of a prevailing wage does vary. In most cases, it's going to be at a very minimum 90 days. If you're getting a prevailing wage now, it's probably going to be valid until the following June. So typically the wages change at the end of June. And so July 1, you'll get a new wage that goes into effect. And so most prevailing wages that are issued in the, second, third, fourth quarter of the year are going to have a June end date. You can start recruitment at any time while that prevailing wage is valid. Do you recommend a certain number of workers for a batch? That's going to depend on your situation. What I would say is that you shouldn't put all your eggs in one basket. Some larger employers, we've had employers come to us and say, hey, I want to sponsor 100% of my H-2B workers. Well, okay, you can certainly do that. But if you run into problems down the road, you may find yourself in a position of not being able to bring those workers back in H-2. Once you file that immigrant petition, if you're doing consular processing, it can be difficult for them to come back into the country in H-2 status. So you may want to stagger it. You may want to do them in groups. I think a lot of larger employers have sort of done batches in groups of 5 to 10 workers, no more than 20 on a single batch. And that gives them the flexibility to stagger things and do it over time. And that tends to be optimal. If you're a smaller operation, maybe you do want to do a larger number of workers, and maybe that's not as critical to you as far as being able to get them back. Or maybe if it's H2A, you're not worried about the H2B lottery. That could be a factor in that as well. So it does vary by employer. It's something that you'll probably want to talk to us about based on your individual circumstances, and we can help you think through the logistics there. Can you tell me a little bit more about what an audit looks like? Yeah, an audit is basically a notice that you get via email, and it says, hey, give us some documentation on your permanent labor need. In a lot of cases, it's just asking you to verify that you do have year-round employment available, right? So if you think about a temp need statement that you would need to show your H-2A or H-2B eligibility, it's about showing that you have a temporary need. This is about showing that you have gainful employment year-round and that you have the ability to employ them on a full-time year-round basis. The other thing that might come up in an audit is your ability to pay. So you may need to show financial documentation of some kind that demonstrates that you can afford to pay the wage that you've advertised to the full number of workers that you've chosen to sponsor. So just showing that your operation is big enough to support a workforce of that size. The other thing that they ask for in virtually 100% of audits would be proof that you complied with the recruitment obligations. So they would want to see documentation on the job order. They'd want to see copies of the newspaper ads, and they'd want to see any, information on applicants that applied to the job. So it would be a matter of putting together a recruitment report. So generally speaking, it's a routine process. It's not overly burdensome. At most, you would have to just furnish some basic, tax documents or something like that to show revenue and net profit and things like that. Can a J-1 visa holder adjust to H-2B and then to an EB-3 visa? It's certainly possible. There's certainly limitations on student visas converting to H-2B, and the cap is certainly an added complexity there. Generally, what I would say is that I would not recommend kind of doing a, adjustment to adjustment to adjustment. It's probably best in that situation to just try to come in organically on an H-2B visa because that wouldn't require a separate petition, and then pursuing the adjustment of status if that's an option. So something to consider there. Why does the employee need their own attorney representation, and how do they partner with Moss Labor? Yeah, so it's both a practical issue and a legal one. So we are not a law firm, and we don't have an attorney-client relationship with the workers. We represent employers. We work with employers. We don't work with workers. And in fact, legally, we are not allowed because only attorneys and certain nonprofit organizations can represent individual workers in immigration proceedings. And so what we've done is we've kind of figured out an optimal business model where it is more expensive to use an immigration attorney that is turnkey, that does this whole process from start to finish. What we've done is leverage our economy of scale, leverage our expertise, leverage our efficiencies to be able to reduce the cost of the employer side of the process. And we've been able to do that at a very, very affordable price point that's below what most in the immigration law space are charging. We've then been able to sort of isolate the worker side of things and have the immigration attorneys specialize in just that piece. So it's leveraging both of our comparative advantages to reduce the overall cost of doing this program. So it's both a limitation on our ability to represent workers, but also this model gives us the most efficient outcome and the cheapest outcome while still maintaining the quality standards. And so it's just a matter of maintaining that boundary with the worker. As far as how it works in practice, again, we work with a network of very, very affordable, but also very, very competent immigration attorneys who just do that worker side of it. And we coordinate with them on all parts of the process. So when it comes to coordinating the petition, we're absolutely right there hand in hand with the attorney, and they help take it across the finish line with the worker. Can the H-2B worker continue working or travel back and forth to their country while they are waiting on adjustment of status, even if the H-2 contract is over? The answer is no, until they get their travel authorization and their work authorization. So if they are doing an adjustment of status, they have to stay put in the US until they're authorized to leave. So again, that takes about 6 months after we start that adjustment of status process. So there may be some gaps in employment where they are not allowed to work and not allowed to leave. Hopefully we time it so that we minimize any of that. Sort of the ideal situation is filing for an adjustment of status as soon as possible after the workers arrive in H-2 status, because they can hopefully run out the course on their H-2 contract and have no gaps in employment. And we've seen that happen. So just something to consider there. But yeah, they are not able to work or travel until they get that interim authorization in the lead up to their green card. Now, what I will say, if they're not doing an adjustment of status, if they're doing the consular processing route, it does prevent them from coming in to the country in H-2 status. There are exceptions though, and it is at the State Department's discretion. So it is not a given that they're not going to be able to come back on an H-2 visa. If they're doing the consular processing route, they might. It's just an individualized determination, and that's something that you'd want to work with us on. Okay, we have 2 workers that are getting close to their green card. We started the process in summer 22. We used a lawyer. If we want to attempt for the family to come to visit while he's here on an H-2, what can we do in advance of the hopeful arrival in April? Do they need passports? Does Moss Labor assist with filing for his family to visit? If the family's just visiting, just for a short-term visit, that's just a regular tourist visa. So they would just need to get a B-2 visa. They can apply directly to the State Department for that. That's not something that we can assist with. If it's an H-4, meaning that they intend to live with the worker while they're here in H-2 status, we can certainly assist with that process. So what I would recommend is just talk to your case manager, mention that you're interested in pursuing an H-4 for the worker's family, and we can get the ball rolling on that. If green card holders do not want to work for a full year and want to return to their home country for a few months, will that be a problem? No, once they get their green card, they're good. They can leave, they can come back, they can live in the US and stay here as long as they want. It's indefinite. They're treated as any other, they have the same rights and privileges as someone who's a US citizen in that regard, right? They can travel, they can do whatever they want. The green card is basically they're a lawful permanent resident. And so if they want to go home, they are certainly free to do that. Yep. What are the risks of starting this process besides time? In what cases would people be denied the visa in the end? Can they become ineligible for H-2 if that happens? Time is the biggest risk. I do think that it's a very unforgiving process. And so you want to have all your ducks in a row because there are going to be setbacks. And I don't know that people would be denied for the visa unless they were generally ineligible. So if they had a something in their record that made them ineligible, like violent crimes or prior illegal presence. Part of the reason why we suggest sponsoring your longtime H-2 workers and not workers that maybe have only worked for you for a short time period is simply because they have that established history, right? You know the worker, you know that they haven't had any major red flags in their history, and so they're less likely to be rejected for an immigrant visa, right? So if they've been coming successfully in H-2 status, that's a pretty good sign that they don't have any major issues in their record that would prevent them from getting an immigrant visa. Now, I will say that's something that the individual worker attorney can help sort out. You know, they can talk to the worker, go through the history, and find out if there's any major red flags. As far as being ineligible for H-2, that's not something we really see in practice. Generally, if they're ineligible for H-2, they'll also be ineligible for an immigrant visa. I don't think we'd see it in the reverse where they'd be rejected for an immigrant visa, but you know, have something where they would continue coming in H-2. But it wouldn't be because of their rejection for an immigrant visa that would prevent them from coming in H-2. For batch applications, do all the workers normally receive green cards? Is it possible for some in the batch to get green cards and not everyone in the batch? Yeah, workers do drop out or employers choose to withdraw them. It does happen. You know, it's a long enough process to where when you're talking about a 3-year timeline, lots of things can change. The employer can change their mind. The worker can change their mind. Maybe something comes up that the worker, you know, they had a baby, they got married, all sorts of reasons why a worker might drop out. We have seen it happen. In general, though, it's if everybody's in it to win it, if they're committed to the process, and there's no major objections and no major issues with the filing, there's really no basis for some to make it, but not others. Where you do see a lot of variation is on the timing, because again, everybody's going to be on their own individual timeline. And so we've seen worker approvals come in months apart from workers that were submitted concurrently. So we filed it on the same day, and there was a 3 to 4 month difference in when they were actually approved. Hard to say why that is. It's just how the government works through the workload, I guess. But you do see a lot of variation in timing, but typically not much variation in terms of approval or denial. What kind of assurances does DOL need from the employer side? Mine is a relatively new company. It's profitable, but it's a small company. Do you need to send tax returns, and how do you prove that you're able to pay? Yeah, tax returns would be a good way to do it. Certainly any type of quarterly, you know, wage statements that show the size of your workforce, show the number of employees you typically have. I would say 4 years operating is not abnormal. Certainly we've seen it. It would be a much tougher time if you were a brand new startup and didn't have any documentation to show. So I wouldn't necessarily worry about that. I think it's just a matter of showing that you have good business records that can show that the number of workers you're sponsoring are legitimate, right? That you have a legitimate business need for it. It's not that different than the analysis you'd go through on the H-2B side to prove that you have a bona fide business need, right? So wouldn't worry about that. It's certainly something we'd help you, you know, talk through exactly what we need to provide, but we typically don't see problems on that front. It's sort of a pro forma exercise. How many other perm visa slots remained available in 2023? I believe the visas lasted until, I want to say, August. So I want to say they were current until the month of August. The visa bulletin is updated on a monthly basis. And so I think starting in August or September, it went into retrogression, which means it was oversubscribed. And it has been oversubscribed since then, which means there's just far more demand, especially from Mexico, in that category. We do expect more visas to become available either April 1st or October 1st. That's typically when sort of new visas become available and it gets current again. Hard to say though. It's just something we keep an eye on a monthly basis. Do all possible green card workers required to get a medical exam? Yeah, there is a medical portion to it. There is also a biometrics appointment. There's a lot of paperwork that goes on to the worker side of things. That all happens at the very tail end of the process. But I think it's fairly routine. I haven't heard anyone have any major issues with it. What are the periods where the men are not allowed to work, and what happens to their H-2B eligibility? And this is for an adjustment of status. Yeah, so they're allowed to work for the totality of their H-2 contract period. So if you're certified for an end date in December, that's how long they have to work. And once their H-2 contract expires, that's when they have to stop work. So again, it really, ideally, you'd be in a scenario where you would, if you're doing an adjustment of status, you would do it early in that H-2 contract period because that minimizes the risk of having a gap in employment. And so the gap would be any amount of time between the expiration of their H-2 work authorization and when they got their perm interim work authorization in the form of an EAD. So again, it's about a 6-month window for getting that EAD. I'm told that the Biden administration is working on a premium processing option for the EAD. Should that come to pass, there probably wouldn't be any gap in employment other than the 2 weeks it takes to process that. So we're crossing our fingers and optimistic that the Biden administration will move forward with that because it's a silly thing, right? To have the worker here but not able to work and pay taxes. Nobody really wins in that scenario. So that was a White House proposal that came out several months ago that we're optimistic about. Okay. At the immigrant petition phase, the family is selected. How does that work compared to a single filing? So on the actual petition, it's just a matter of identifying the family members that they intend to bring with them and to sponsor for family-based. If the family members are pursuing consular processing, it's a straightforward process with the consulate. The petition only really looks different if they're concurrently doing adjustment of status for the family members. That's a whole separate process, and each family member would have to do their own adjustment of status petition. So it does increase the paperwork. There may be additional fees charged by the worker attorney for that work. On our end, on the employer side of things, the process looks completely identical. Okay. We have an individual who was approved for a green card 14 months ago, received 2-year work authorization and 1 year of advanced parole. Green card has not arrived and advanced probation has expired. What is the best course of action? That's a conversation to have with the attorney who did the original work. They can help sort of reapply for that. And there is a process for reapplying and renewing that. I would just recommend talking to the original attorney who did that work, and they're in the best position to advise on that worker's specific circumstances. If you're put on a waiting list, do you have any idea how long it generally takes? About a year. I mean, it certainly depends on the visa availability under the visa bulletin. We've seen cases where it's gone faster. This is where employers can really leverage their political connections, because one thing that every member of Congress can do is help move you to the front of the line. And we've seen that happen where members of Congress will intervene and help expedite those processes. So, that is a scenario where you can sort of use the connections available to you to help expedite. But generally speaking, most people are waiting a year or more to actually get those. So, but again, it just depends on availability. My workers have been working with me for 20 years. How do they get 3 months experience outside of my employment? Generally, they can't, unless they had relevant work experience prior to working for you, or if let's say they work in their H-2 off season, if they work a similar job back in their home country, they can get experience that way. In that scenario, if we really can't cobble together relevant work experience, the recommendation would be to just not include an experience requirement in your perm application. What I will say is that there's very few U.S. applicants who are applying to these jobs, and so it's rare for us to get any U.S. applicants that actually qualify, even when there is no experience requirement. So it's something to talk about, but we've been successful in just dropping the experience requirement and having no problem moving forward with it. And if there is no experience requirement, then there's nothing to document. The worker should be completely fine. Do you have to offer year-round employment? Yeah, that's one of the requirements. So again, this is sort of the inverse of the H-2 world, where you have to demonstrate that it's a temporary employment situation. With the green card process, you have to demonstrate that you have full-time year-round work available. And what a lot of employers choose to do is figure out what duties are available in the off-season. For landscapers, maybe that's snow removal, right? And you can just add that to the job description, and you can find gainful employment in your winter months. But of course, it depends on what your business circumstances are and whether that's viable. Are all H-2A workers eligible to apply for a green card? On the surface, yes, right? So there's nothing about H-2 in particular that makes them ineligible. The only ineligibility comes at the individual worker. So again, if they have something that would preclude them from getting a green card, like a past illegal history or something like that. But generally speaking, no. Any employer can choose to sponsor any worker they want. And there's nothing about being in the H-2 program, H-2A or H-2B, that would prevent that from moving forward. Is this process legal and worthwhile if you need seasonal help only? So again, this is really about solving year-round labor needs. So if you are a very, very seasonal business and you don't have full-time employment in your off-season, it's probably not the right fit. You'd probably want to just stay in that H-2 world where you can get workers on a seasonal basis. This is really about year-round needs and filling workers on a permanent basis so that they become part of your permanent workforce. Can an H-2A worker remain in the USA while the process advances, or do they have to return home after the 10-month visa concludes? Yeah, that's going to depend on how they're getting their green card. If they are doing the adjustment of status, they can stay. So their H-2A contract expires. They've already filed their adjustment of status. They're good to go. They're legally allowed to stay in the US while that process plays out. If they're doing consular processing, and because let's say visas were oversubscribed and not available, if they're doing consular processing, they do have to leave at the end of their H-2 contract, just as they would in ordinary circumstances. Most of our employees have been working for us for several years, and maybe this is their first or second job experience. Would they apply for an EB-3 visa if they? Yeah, so again, the work experience is only necessary if your job opportunity has an experience requirement. You can always choose to not list an experience requirement, and then the worker's work history is just not relevant. They don't have to show anything. They would only need to show experience if you had that as an experience requirement. Will we have access to the recording? Yep, it'll get circulated. What are the reasons why a worker would get denied a green card? Again, prior illegal presence, something in their history that if they committed crimes or they were convicted of felonies or something like that, that could be a basis for it. Is the green card permanent or does it have an expiration date? It is permanent, right? It does not need to be renewed in that sense. So they have it for life, basically. It's renewable indefinitely. The actual document does have an expiration date, but the process for getting a renewal on that is very straightforward. They do not have to go through all this rigmarole again, right? It's a very straightforward process for just getting a new document. But the status, the lawful permanent resident status, is permanent. Okay, once the worker gets an EAD, can they go back home to visit family for short times? Not the EAD, but the advanced parole. So they typically get those at the same time. So when they get their temporary work authorization, they will also get their advanced parole, and that's the travel authorization. So that's what allows them to travel home for short visits. So that is possible. It's just, it's a different document, typically issued at the same time. Where is the visa bulletin at currently on its visa availability? So right now, in the month of January, it is oversubscribed. So it is listed as being in retrogression. Visas are not available. Again, we expect more visas to become available probably in April of this year. And if not April, we're hopefully it's by October, is typically when they do the updates to it. So we haven't seen any movement in the past few months, but certainly we expect changes by April. And I probably have time for one more question. Once a worker gets the green card, how much longer to get to the family-based immigration? Yeah, that depends. I can't really speak to that because it's going to depend on a lot of different factors, like how the family members are doing it, whether it's adjustment versus consular processing. But there is a whole process involved in that, and that's probably something to discuss with the worker attorney. And I'll answer one more. Ed, I got you here. How will the regulation changes for dual intent impact the process you've just outlined? So there is a new rule that is being proposed by the Department of Homeland Security to allow dual intent, meaning it's not going to interfere with their ability to get a green card or their ability to come in H-2 status if they are pursuing a green card. This would be a very welcome change. What it means is that if DHS moves forward with that rule, there should be no issue having the worker continue to come in H-2 status while that green card is pending. So there's no sitting on the sidelines. There's no waiting forever and ever for an appointment to become available. They can keep going business as usual and come back in H-2 status until a visa becomes available, and then they can convert, as soon as possible to green card status. No gaps in employment. Everybody wins. That's one aspect of the DHS rule that we certainly support and hope moves forward. But yes, that could be a game changer relative to what I just outlined. Okay, and the rest of the questions, sorry, we ran out of time. What I can probably do is catalog these, and then we can include answers to them when we send out the recording. But really appreciate everyone's time. I know we ran a minute over here. Certainly follow up if you have any questions, and we have a Calendly link. Just go to calendly.com/MOS365. You can book an appointment on our calendar, and we can have an hour-long conversation about your specific business circumstances, and hopefully get all your questions answered. And if you want to move forward, that's really the best way to do it. So appreciate everyone's time, and thank you very much for attending.